Nearly 270 billion emails are sent each day around the world. The data from those messages is stored on servers in well over 100 countries, from Canada to Japan. Those servers, or more specifically, whether the government can access those servers, is at the center of a case now before the Supreme Court. Microsoft was served a search warrant in a U.S. drug trafficking case. The Justice Department wanted the emails from a user's Outlook account. Microsoft refused to hand over content of emails because they were stored digitally in Ireland. And they argued that if the Justice Department wanted those emails, they were going to need to get permission from Ireland. This case is more than just about privacy. In the age of cloud computing, it's become a battle over national sovereignty. Jennifer Daskal teaches at the American University School of Law in Washington, D.C. Used to work for the Justice Department as well. It's so nice to have you walk us through this case, which is kind of complicated and confusing.
So Microsoft's argument is you have a warrant. Warrants only reach the territorial boundaries of the United States, and this data is outside the United States. You can't get it. If you want it, you have to go to Ireland and ask the Irish government to get it for you and turn it back over to you, the U.S. government.
What's the government's case?
The government says, that's crazy. You're based in Redmond, Washington. You can access this data from Washington without ever stepping foot in Ireland. All you have to do is press some buttons. The data comes back here into Washington. This is clearly a territorial exercise of our authority. Nobody's crossing borders. We're not crossing borders. We're not asking you to cross borders. So do what we're asking you to do. This is perfectly permissible.
One could imagine that a company, if Microsoft's side wins out, could say, oh, let's start storing all of our data on servers in some country that would be very hostile to ever handing over the data if we were ever involved in any kind of legal action, sort of like people who hide their assets in offshore accounts.
And that's exactly one of the government's key concerns, is that they're investigating what they deem to be legitimate crimes, legitimate investigations. They've gone to a court. They've gotten a warrant. A judge has stamped the warrant and said, this company needs to turn over this data. And the government's saying, we're not able to access that data. That doesn't make any sense. If the data were here, there'd be no problem. Simply because some company decided to move it overseas shouldn't change our ability to access this information.
But you could see if the government wins its case, it wouldn't be a far stretch to say, so other countries, China, for example, could say, hey, we would like the data that is Chinese national, but it's all stored in the United States. And that, I think, would then make people hesitate.
Right. So that's the converse side. That's Microsoft's argument. And Microsoft says if the government wins, it sets this really concerning precedent that countries all around the world assert access to data anywhere.
It was, I think, 1986 was the last time that Congress even thought about restricting the government's access to electronic communication. In tech years, that's 5 bajillion years.
Right. So all of this case is about interpreting this 1986 statute. It was written at a time before there was a globally interconnected internet. It was written before anybody could have conceived of a situation in which Microsoft, Google, and Facebook were storing data all around the world and moving it around with the rapidity with which data now moves. And so there's a real need for Congress to step in here and to update the laws.
Now, there is a proposal, right?
Yeah, so there's good news. There's a bipartisan proposal. Two Democrats, 2 Republicans have pushed forward something called the Cloud Act, which would say, basically, consistent with what the government wants, that the government's access to data shouldn't turn on where the data is actually located, but it also has in place certain protections designed to respect the interests of foreign governments in legitimate situations as well. And interestingly, both the government and Microsoft in this case support this legislation. And at the hearing on Tuesday, you had several justices saying, shouldn't we just let Congress fix this?
What do you think if it, in fact, ends up just being the Supreme Court's decision? Any insight in how the justices might tackle the case?
So it was very unclear from the arguments. That said, the Supreme Court took this case, even though there wasn't a split between the circuits. Usually the Supreme Court only takes cases when one circuit says one thing and another circuit says another thing. Here, all we had was one decision, and it was a decision in favor of Microsoft. And presumably, the court took the case because they were worried about the implications, primarily probably the security implications if U.S. law enforcement was unable to get access data based simply on where the data is located.
Jennifer Daskal, nice to have you. Thank you.
Thank you.